Okay, final video for this series. I want to talk to you about the processes for getting completion happening, and also to tie together the many different things that I've been talking about in the video lectures for this week to make sure that you understand the context and pull them together into one place. So you've seen this slide before. I used it in an earlier presentation, but I just wanted to come back to it to just remind you where we are. Now, look, it's not uncommon for completion and the handover of a transaction. So completion and execution of the agreements to happen on the same day, particularly if the business is small or the negotiations have been prolonged and a whole lot of things have been happening up until that last moment. But more often than not, we have a gap between the time that parties exchange signed agreements and we end up with a conditional contract. Well, we might end up with a binding contract, but quite often if there are conditions precedent to the agreement becoming binding, then the agreement is conditional on the completion of those condition precedents. So conditions precedent are something that I've talked about ad nauseum because they're really common and they can be quite complex, and they are as different as every arrangement that you might think of. Now, we did a bit of a deep dive into FERB and when that might apply earlier, but there are a whole heap of other things that could be relevant here. It could be that the agreement is conditional on a license of some sort being awarded, that the landlord agreeing to the ongoing use of the premises, or the shareholders waiving some sort of preemptive or other right that they might have. So it is not at all uncommon, particularly in private companies, for shareholders to enter into shareholders agreements that basically say that give them the right to buy another party's shares if a party wants to sell them, or require a matching or a drag-along right of some sort. Now, we haven't spoken about those in any detail. If they're relevant to your assignment, you should definitely go and have a look at them and think about the ways that they work. But it's a very common condition precedent to either have shareholders or parties to shareholder agreements to write a letter saying that they're not going to exercise those rights, or to waive those rights formally in some way. Another thing that's often really important in the lead up between the document being signed and completion actually happening, is questions around how the business is going to run. What does business as usual look like? So even though ownership and risk may not actually occur until the completion date, clearly the purchaser is taking risk in that intervening time if the owners of the business just decide to stop working or to do things very differently or to badmouth them or to impact the relationship with suppliers or personnel or even customers. So a lot of that is the kind of thing that you're paying attention to in this intervening time. Other things are the corporate law requirements. So clearly, particularly on a share transfer, we are looking at changes to the ownership of the company. So the company secretaries, if there are company secretaries, otherwise the directors in each of the companies need to make sure that the registers are clean, make sure that there are transfers ready to go. If the company still have share certificates, they're gathering those share certificates so that they can be cancelled and new share certificates are issued. Board meetings will need to be held, and so they might be held on the basis that they're delegating somebody to hand over the keys and the bank accounts at some point. But there are a lot of logistic things that need to happen, and even with a share sale agreement, there are some things that will always need to be changed. So whilst the new owners, when they own the share, the bank accounts will stay with the company, for example, but the signatories will need to change. All of these are the kinds of things that we're paying attention to in this final stage. And quite frankly, these are the things that junior lawyers in M&A or corporate teams are often tasked with. It's quite usual to put together a completion agenda. So this is basically a checklist. Its purpose is to ensure that all the completion deliverables are identified, prepared, circulated, settled, and executed if they're needed. if they need to be signed, in preparation for delivery or handover at completion. Frankly, I've been doing this more than 30 years, quite a bit more than 30 years. And even back in the day when we didn't use electronic signatures, it was quite common to have all of the documents signed in readiness to go and then delivered or handed over at completion. These days, it's actually rare to get everybody in the same room, which is a bit of a shame, really, because often after the completion ceremony, there would be some nice champagne, which was one of my favourite parts. So the purpose of the completion agenda is to list all the pre-completion, completion and post-completion issues and deliverables. So that will include the conditions precedent, all the documents that need to be signed. It'll identify the parties or the people responsible for discharging each of those items, and usually we'll run like a checklist that says what's happening. Has it been started? Is it on the way? Are we waiting for something? Is it an issue or is it just in the bag? So a typical completion agenda would include lists of the conditions precedent and any other completion deliverables, lists of all the documents to be delivered at completion, and also the order of delivery, because when you think about it, we need to change the ownership of the company before we change the signatories to the bank account. It will identify the people who need to sign each document that is a deliverable, whether they need to be in the room, whether documents can be signed electronically or not. And usually the person within the advisory team who's going to be responsible for making sure that that happens, along with a list of post-completion actions and findings, the things that we're going to follow up after the event. Vendors, lawyers, have a number of things to deal with. As I've said a number of times, each transaction will be unique. Typically, they'll be the ones who prepare the ancillary documents that will be delivered at completion. They'll need to ensure that these things, so things like the transfers or novations of the lease documents or any other kind of documentation relating to the release of their obligations in favour of the purchaser, they'll need to make sure that all of those are prepared and that anything that's relevant to that transfer of shares is available to be delivered to the purchaser or needs to be deemed to be delivered by being left with them in some way. Usually they'll have a big hand in announcements as well, and a big part of it is actually the running around and making sure people are available on the day. Purchasers' lawyers have really similar obligations. They also have documents that they'll be making sure are prepared. They need to check that the purchaser has made arrangements to have the funds available to pay the purchase price at completion or at the time that payment needs to happen. So sometimes purchasers' lawyers are also working with their banking and finance team, or maybe even directly, to ensure that monies that are being lent to the purchaser for the acquisition are available in cleared funds on the day. And then they may also be working on the security documents. So if the purchaser is borrowing money for this particular acquisition and then giving some sort of charge or mortgage over those assets when they're acquired, or that the company itself is guaranteeing the loan in some way. Sometimes it will be a loan directly to the purchaser. Sometimes it might be funds that are going into refinancing the company or the target company itself. Every transaction is unique. They can all happen in different ways, but the purchaser needs, or the purchaser's lawyers need to make sure that these things are all in place at the end of the day. Often at completion, we have a range of different meetings. Now, these always used to be physical, face-to-face meetings, but these days many times they're undertaken virtually, sometimes without even, they're asynchronous, so everything's just basically happening by email exchange. So the meetings and the undertakings that are given, these are required formalities to complete and to implement the transfer of the assets or the shares from the vendor to the purchaser. Completion can occur simultaneously with execution, as I mentioned before, but that requires an unconditional agreement. But in most cases, there's a split between the execution or the signing of the agreement and the completion process to allow time for the satisfaction of those conditions precedent. As I mentioned, completion meetings can occur physically or virtually. Whether they're long or short will really depend on the complexities of the transaction, the kind of business that the target is running, and the extent to which any legal or practical difficulties have arisen in that intervening time between exchange or completion. So what happens at the completion meetings? Basically, that's about delivering the completion deliverables. So these are the relevant ancillary documents, title documents, and they're exchanged between the parties. The vendor will also typically be required to make the company register, passwords, keys, company books, records, financial records, employee records, all of that available to the purchaser. Now, that used to be big boxes of books being handed over, but these days it's really just about passwords. Or setting up new users. Where documents have been signed in advance of a completion meeting, but they haven't been dated, solicitors will often, as they're accepting delivery and checking that everything's been provided, they'll be dating the documents and it'll all be relatively straightforward. Ideally, in advance of completion, the lawyers for both of the parties will have worked through a list of those completion documents. It's one of the ways that the completion agenda is very useful, and settled each form of deliverable. So really the final process is just a checking, sort of, eyes on part of the process. Once the deliverables have been exchanged, the purchaser's solicitors will give instructions for the completion monies to be paid to the vendor. Usually that's happening by real-time transfer of funds, basically in accordance with the direction that has been given by the vendor. Back in the olden days, we used to swap checks, but clearly money, we know, is no longer a physical thing. We understand that. So, notwithstanding prep for a completion meeting, clearly issues can still arise on the day. So that can disrupt planned completion proceedings. People might not show up. There might be bad press on the day. Somebody might instigate proceedings against the target company or the vendors. A whole lot of things can happen. So pre-planning is really essential to ensure that everything is done as seamlessly as possible. And often this is the stuff that junior lawyers are asked to do. It's a great opportunity to learn about the transactions as you go, because it's the things that go wrong between signing and completion that inform your thinking as you negotiate the next sale and purchase agreement. Now, there'll be some additional slides here with just some notes about things that parties think about post-completion. We'll probably deal with these in a little bit more detail in some of the subsequent weeks, but I've used up all of your time and it's valuable and I do appreciate it. So I won't go on about this anymore today. So thank you for your time. As always, questions, concerns, frustrations, compliments or suggestions, please seek me out. Cheers.